of times, probably far too many actually, and I find it, I get a sort of panic attack just before they're going to be sentenced to death. It's just unbelievable how the cells hold the memory. So it comes in two parts. I'm very bored a lot of the time because I've seen it so many times, but then the panic attack starts when they're sentenced to death, but also just before Anton's killed, when John Carlin's talking about the news that's coming through, and I relive it in a sense. So it's very, very tough at those 2 points. And often I don't sit through it. You know, I go and have a whiskey out the back and then come back for the Q&A, but I don't like doing that. I like to actually be with the audience so that I can talk about it with you afterwards, which is why I decided I prefer to be here tonight.
Well,
what were you doing when the appeal was granted? Were you living in Australia? Were you over there?
I was, in fact, that's a great question because I was living in Australia. I went back to do the appeal. My firm, Freehills, let me go back to do the appeal, wanted me to do that. And so we ran the appeal and I was due to come back and I had this absolute sense, probably a premonition by one of the women in Upington who were very tuned in, these women, that the judgment was going to come quickly. So I decided to postpone. I phoned my firm and said, could I stay an extra week? And I did, and 3 days later they announced, and I flew up to Pretoria and went to get the judgment.
And who were the four whose appeals, who didn't get to appeal, and what happened to them?
They all got to appeal. Everyone.
I thought 21 out of
25. No, 21 out of the 25 didn't succeed on appeal. The murder convictions were overturned for 21 of the 25, but 4 still had murder convictions and they served prison terms. Yeah. But all the death sentences were commuted.
I got that.
Okay.
I can't remember.
Just to clarify that though, before that served the prison terms, when we were seeing the names of what happened, some of them served 10 months. Were they those 4? Or were
Yeah, those were the 4.
So they were the 4.
Yeah. And they were specifically chosen to be in the film. You know, the director had a really difficult decision as to who should be portrayed in the film, because you can't have all 25, and she decided on the ones who were the sort of most severe cases.
and endless questions about all the people. And I'm actually going to ask a sort of mundane and different question, but you were a young lawyer doing this, pro bono. What did the legal community think of this? What were you doing? Were you an outlier? Was there support? Was the legal community part of an anti-apartheid movement?
Oh, just to clarify first, I wasn't actually doing this pro bono. We couldn't have done it pro bono because it went on for so many years, and there were all the experts, and we had forensic experts that I consulted with in America. So we were funded by this amazing trust fund that had been set up actually by a South African lawyer, Billy Frankel, who left and went to live in exile in London. And he set up what's called the South African Defence and Aid Trust, or fund. And it was he was a superb commercial lawyer, and he conceived of this very complex way where people in Europe and England could get pen pals who happened to be the members of the families of the accused, and send them letters as if they were pen pals, but actually what they were sending was money. Is that the way the money got through to the families? And then it came through to us as law firm. We could get some money through my law firm from the trust fund as well.
So you were working for a firm who was allowing you to work solely on this case,
Yeah.
principally on this case.
Yeah. Amazing law firm that they were.
So what was the approach to the legal profession?
So the profession was a very mixed approach. The legal profession in this country were amazing, and around the Commonwealth world were amazing. When, as John Carlin says, when the news got out, I got amazing letters of support and offers of giving me legal advice from the bikie trials in Bathurst, actually using the Commonwealth spectrum, from people like Chris Kineen and Nick Cowdrey and Penny Andrews, who'd heard about it. So there was amazing support from the legal profession outside the country. Inside the country, of course, my colleagues, there were a few of us who did this kind of work, and they were incredible. But a lot of the time, I was seen as kind of a white woman hanging out with black communities, and it wasn't very cool. And I was doing, obviously these people were guilty, and what was I doing? And I was very keen to ensure that in the film, and Mitzi was good about this, that we demonstrated the horror of the crime and the horror of what the mother of the deceased went through for that reason. And I was always very conscious that someone had been killed brutally. But I was also very aware that my clients were there, most of them at any rate, were there and shouldn't have been there. So I think most of the legal profession saw the killing and the brutality of the killing and thought, what was this white woman doing, defending these people?
And it's such a moving story, and so beautifully done. So thank you for that.
Thank you.
The issue that stands out for me is this complicity of the legal system in holding up oppressive regimes. And the title of the book, as it came out of the US, which is a common purpose, is the doctrine that is at fault here, it seems. Now, we've got a vindication at the end of the day when it comes to perhaps the factual stuff and the evidence, but presumably the doctrine of the common purpose remained the same and was used in other instances prior to this to address the issue of the right of freedom of association, which is crowds and crowd violence.
Very much so. You know, I'm so pleased you asked the question that, because it has been used in very recent South African history, as you probably know, in the Marikana mines inquiry, where all the miners were killed by the police. The prosecuting authority, in its madness, actually arrested all the miners, the 74 miners, or however many it were, who were arrested, were going to be charged on the basis of the common purpose doctrine. And the inversion of the doctrine in that instance was, they argued that the police, the miners had incited the police to shoot at him to kill them. And they were in a common purpose towards their suicide, is what the argument was. And I was phoned by all these lawyers saying, how can this be right? Can you use the doctrine? So we did all these submissions to the prosecuting authority, and they actually eventually saw reason and dropped the charges on that basis, though some of the charges are still going. And the Marikana inquiry is now looking at something very similar. And what's interesting is my counsel was Anton Lubowski, but our senior barrister was a man called Ian Phylum, and Ian Phylum is now heading the Marikana inquiry. So there are all these, interweavings.
But the doctrine remains.
The doctrine remains, and it's actually a very sound doctrine. It's often used, it comes obviously from the English tradition, which we inherited in South Africa, but it's often used in a sort of bank robbery. I talk about it in the book, in a bank robbery situation where three people come together to rob a bank. One of them takes a gun, and in the fracas, the gun is fired and someone is killed. And all three, the doctrine says, should have reasonably known or anticipated that someone with a gun in a criminal enterprise could lead to someone's killing. So all three are held liable, and that's the correct application. The correct application was also used in the case of an inquiry into Anton's murder, where the judge, Levy, at the end of the inquest and the inquiry, held that 10 members of, and this is Orwellian South Africa, apartheid South Africa for you, 10 members of what we call the Civil Cooperation Bureau were guilty of Anton's murder under the common purpose doctrine. So it came full circle. They were nothing ever happened to them because it was an inquest finding rather than a criminal trial.
Your ambitious hope for law, I was thinking of, I took since more than once before, and I reflect on the fact that ultimately your client's justice was done, if you like, unexpectedly by the three Conservative appeal judges. You expected them, in fact. You wouldn't have been surprised had they dismissed the appeals.
No.
Would you have felt any different about the law, but for the three judges giving you what you thought you should get, although you didn't actually trust them to do it? Had they decided the other way, would you be thinking any differently about the law? Is that the only thing that made a difference, that 3 judges saved your faith in the law?
No. I mean, it's a really important question, but no. You know, there were times when, during the trial, when I thought, what's the point of all of this? What are we doing? Everything's so against us. Why don't we just storm the Bastille and be done with it? And I always used to say to my clients, you know, we have to be meticulous in the way we run this because we want the best, most infallible record for the appeal. And I had this kind of belief that in the justice system somehow,
if you were a good lawyer,
it would somehow, and I think I've always had that faith, and I think I would have been deeply, deeply damaged by a finding that wasn't what we got. But I don't think it would have stopped me in the fight that I'd always believed in. Probably would have made me somewhat stronger.
Yes.
Is there also a follow-up there about the interplay between law and other forces in society, so that there can be occasions when you don't actually get the result you want in the judgment, but that negative consequence leads to a ricocheting in other aspects of society where there's no guarantee, but that the media response or certain government lawyers who suddenly see in stark contrast the injustice prompts them to action, so that it's not necessarily that the legal frame is not necessarily the only thing that we look at. It has to react with other things.
I think that's absolutely right, Kim. Yeah, no, I do. And I think part of that was my desire to work very closely with journalists that I trusted, to make sure that some record of this was getting out in some way to persuade governments around the world or even our own populace in South Africa about these kinds of stories. And this was one in thousands. I mean, it wasn't of the nature or the extreme perversion of the law. You know, it didn't have a lot of these Upington cases, but it was one of thousands of people being treated like this by the law. So there's a wonderful story I haven't told Simon. I've been dying to tell him, but I said I wouldn't until tonight. But recently Justice Becker called me to tell me that his dream had come true. You probably remember me saying that when they were sentenced to death, they were allowed to speak to the court, and they said, Justice particularly said, his line was, I hope, to the judge, he said, I hope that one day you and I will be able to walk together in a free South Africa. When I went back to South Africa to work on the film, we tried to make contact with the judge, and I was told he died of cancer, and so I sort of left that. And Justice phoned me. He was hysterical. He said, something unbelievable happened to me this morning. I bumped into the judge. He said, my dream has come true. And I said, really? And he said, yes, and you won't believe it. He lives around the corner from me. I drive past his house every morning. I take my daughter to school, and I drive. And he's very, very old, of course. And I said, what did you say to one another? He said, I recognized him, he recognized me, and he turned to me, we didn't know what to say. And I said, how are you? And he said, I'm all right, how are you? And Justice said, I'm not bad. And the judge said, the one thing I remember about you is how beautifully you all sang. So he said, it was, you know, he said, what do you say to that? Well, thank you very much. That's lovely. I'm very pleased you enjoyed our singing. But it was this, he said, well, you know, at least we left that imprint, if nothing else.
Now, I wanted to ask you about the law in South Africa. You've been back with the film since, and there's it's a different world. This is news to people, what's in this film.
And it's news to the new generation of South Africans. I went back to show it at an international film festival, and then I went back, my university asked me to come back to do a big screening, it's news to what's known as the born free generation, which is the generation now that is sort of 20 years since apartheid was overturned, and there are these law students who come up to me who say, we didn't know the extent of apartheid. We didn't know this is what it meant. And I said, don't your parents tell you? No, we're all getting on with the new South Africa. And a lot of the parents came to me to say, thank you for this film, because it tells the story of what we went through to our children. When we try and tell our children, they're not that interested. they're too busy wanting to make new lives for themselves, and absolutely so they should be. But there's this kind of, not amnesia, but a kind of, just a sort of kind of severance of that past that was so grotesque and so brutal that who would want to really know about it? So it was quite shocking to me. In fact, Mitzi Goldman, the director, came with me to we went together to the Encounters Film Festival, and a lot of the young black kids who came up to her afterwards, she was expecting they were going to say, what an amazing story and how terrible, and they all wanted to know how they could become film stars. And she was shocked, and I said, no, I think that's fantastic, so that's what they should be saying now. You know, they would never have been able to say that 20 years ago. Like, in Essentia, you know, going to school was beyond her wildest, going to college was beyond her wildest dreams, and that was my parting shot to her. I put her through college, and I said, before I leave, this is what we're going to do. And she said, I don't know how to go to college. I said, yes, you do. And I found that guy who's seen the pink shirt and said, will you take her to her first class? And he said, yes. And I thought maybe he'd be a nice husband eventually.
Yes.
Yeah, thanks, Duncan. I have a question about the Truth and Reconciliation Commission process, the storytelling, and it's quite formal, and people are supposed to reconcile, you know, through that process. But this seems to be doing the same kind of thing. But that Truth and Reconciliation process has been tried in other countries as well, so it seems to be, you know, like an established pattern. So can you tell us what you think about that, if it's a worthwhile process? And then a very quick question, is this story in there's an anti-apartheid museum, I think it's a Doug Hunsford funded in Port Elizabeth, and they've got a lot of these really, really distressing exhibits, and I don't recall seeing this story there, but it may be, so is it there?
Is this in Port Elizabeth? Okay, I don't know about that one. I know about the Apartheid Museum in Johannesburg, where, so the footage you see of the nooses and is taken straight from a death penalty cell and into the Apartheid Museum. That's where it was filmed, with their permission. But no, the story, you know, it's in various, the University of Cape Town Archive Special Collection has asked for I've got boxes and suitcases and beautiful things that they've made for me. In fact, one of the paintings you see of the depiction of the court, there's a water painting. I've given that to them, and they've made matchstick boats that they made in prison. And I've given, so they're very keen to have this record of the trial at the University of Cape Town. But no.
And the TRC?
The TRC is, I think, I have very mixed feelings about it. I think it's a remarkable sociological phenomenon that had happened. It brought apartheid into the bedrooms, the living rooms, the kitchens of South Africans who didn't actually know what was happening down the road. People, you know, it was on the news every day, through the radio, through the press. It was amazing, and it travelled around like a TRC caravan around the country. And I think for that it was amazing. I think, and it's easy to say in retrospect, because it was such a difficult undertaking, but I think that the reparations dimension of it has been very disappointing. And I always say to people, I know that the country has different imperatives. It has to use whatever resources it can to basically bring water, electricity, housing, education to millions of people that never had it, let alone pay reparations to victims. So, you know, the reparations payments were very disappointing. My clients particularly, I found it, none of them really got anything except Evelina. In the end, we fought, and she did get a house. She's now died, but she got a little house. And I think there's also, the lawyer in me wants accountability. And I felt very upset for a lot of people who bore such tales of horror in this very public forum, and that was it. They never got to go to court and hold those perpetrators really to account and get convictions. But then you look at cases like the case of Dr. Death, who was a notorious cardiologist who spiked the drugs of activists, of political leaders, put acid in drinking water. He concocted the most incredible schemes, chemical sort of warfare. And he went on trial, and the state spent millions and millions of rand on this trial, and he was acquitted. So I have a real ambivalence. I think my overall reaction, in short, is that I think it was a remarkable contribution to the TRC, but with those kind of provisos attached to it.
As I said to you before, I read your book, Upington, when I was a social psychology graduate student, thinking about the interface between law and psychology, which is where I now work. And as a social psychologist, always quite impressed that social psychology was used for the de-individuation arguments. I was just wondering what the reaction was to that, because even now, I suppose in Australia and elsewhere, clinical psychology rather than social psychology might be more of the norm as the expert testimony that you see in trials. So maybe you could say a little bit more about that and exactly whether the de-individuation arguments were all about the common purpose being able to be formed or not, evidenced or not, or whether it was a mitigation argument or
It was
the strength of it.
Well, thanks for the question, but I think it was purely for our purposes where we didn't have clients as individuals who would tell us really what happened, because the collective was so strong amongst them. You know, I actually tried to break that down because as a lawyer I felt it was my responsibility to try and save them from the death penalty. And so I would say to them, as I say in the movie, you have to come clean, you have to tell us, so we can build a case on extenuation, why you did what you did, because you've been found guilty. That's what we have to work with as lawyers. I know that maybe you weren't guilty, but the courts found you guilty, so that's the mud we have to work with to craft this extenuation argument. And there were some cracks, but the next day, the collective came back, and the common purpose was so strong. You know, Justice Becker-Becky, and I can talk to him about it now, he tells the TRC that he committed the murder, but 25 other people were dragged down with him. He could have turned around, and I think there was one moment where he did say, I will carry this on my own. But the politics of that experience for people was that you went down together. And so his own brother was one of the convicted, you know, and May Nabova, his best friend. So we had to work around that, and I think the de-individuation theory, which had been tested, as I said, in the trial before, that's all we had to work with to try and save these people. And I think it was really kind of our last resort. But I also thought it was a very plausible, definitely a very plausible explanation for their conduct. So I don't know if that answers the question that you asked.
Yeah, it's mainly a mitigation argument.
It is a mitigation argument entirely.
About whether rather than an argument about whether a common purpose was evidence, whether there was an agreement that had been evidence.
No, there wasn't. No.
Mitigation,
I'm about to change role and become Andrea's driver, so I'm watching the clock. We're going to need to finish. Can you join me in thanking you very much for